Most people think estate planning begins with a will. That is the first mistake. A will is important. In some situations, it is essential. If you have minor children, you almost certainly need a will because that is where you nominate the person you would want to raise them if something happened to you. But a will is not the master switch most people think it is. A will does not control everything you own. That sentence surprises people because they have been taught to think of a will as the document that decides where everything goes. They imagine that if the will says, everything goes to my children, then everything must go to the children. But the legal system does not work on imagination. It works on structure. Estate planning is not mainly about what feels fair. It is not mainly about what you meant. It is not mainly about what you told your family at Thanksgiving. It is about three mechanical questions. Who has control? When does control change? How does the asset legally move from one person to another? If you understand those three questions, wills and trusts become much easier to understand. If you do not, you may create a plan that feels correct emotionally but fails legally at the exact moment your family needs it most. That is the danger. When a person dies, the law does not sit everyone down and ask what the person probably wanted. The person is gone. They cannot clarify, they cannot explain, they cannot say, no, I know the beneficiary form says my brother, but I really meant my children. The legal system cannot run on guesses, so it runs on documents, titles, contracts, and court procedure. The structure controls not the emotion, not the family story, not the old conversation, the structure. Assets usually move in three ways when someone dies. They move by contract, they move by title, or they move by probate. Once you see those three buckets, the whole estate planning conversation changes. The first bucket is contract. Some assets pass because you signed a contract with a financial institution or insurance company. A life insurance policy is a contract. A retirement account with a named beneficiary is a contract. A payable on death bank account is a contract. A transfer on death brokerage account is a contract. If you name a beneficiary, that beneficiary designation usually controls where the asset goes when you die. The company does not ask what your will says. It looks at the beneficiary form. If the form says your sibling receives the life insurance, then the sibling receives the life insurance. That is true, even if your will says everything goes to your children. The beneficiary designation wins. This is one of the biggest hidden mistakes in estate planning. People create a new will after divorce, remarriage, a child's birth, or a family change, but they never update old beneficiary forms. Then they die, and the money goes to the person named on the contract, not the person named in the will. No one is ignoring the will. The will simply does not control that asset. The second bucket is title. Some assets pass because of the way ownership is titled. If you own a home jointly with rights of survivorship, the surviving owner may automatically become the full owner when you die. If a married couple owns a joint account with survivorship rights, the surviving spouse may become owner automatically. Again, the will does not override that ownership structure. This can create serious problems in blended families. Imagine a man in a second marriage. He owns a home jointly with his current spouse. His will says that his share of the home should go to a child from his first marriage. He believes the will has protected that child. But if the home is titled with rights of survivorship, then when he dies, the current spouse becomes the full owner. The child receives nothing from that home under the will because the home never became a probate asset controlled by the will. The title controlled. The will did not. This is where many families feel betrayed by paperwork they never understood, they say. But he said he wanted the child to receive his share. That may be true, but the legal system follows the ownership structure, not the conversation. The third bucket is probate. Probate is the court supervised process for transferring assets that did not already pass by contract, by title, or through a trust. A probate asset is an asset still owned in the person's individual name at death, with no beneficiary designation, no survivorship feature, and no trust ownership. This is the bucket A will controls. That means a will does not control all assets. A will controls probate assets. That one sentence can prevent enormous confusion. A will is not useless. It is not optional for many families. It is not something to ignore, but it has a specific job. It tells the probate court how to distribute the assets that fall into the probate bucket. If an asset never enters that bucket, the will does not direct it. This is why estate planning begins with asset mapping. What do you own? How is each asset titled? Does it have a beneficiary designation? Is it jointly owned? Is there survivorship? Is it inside a trust? If you cannot answer those questions, you do not know what your will actually controls. You may think you have a plan, but what you really have is a document floating above a set of assets that may be governed by other rules. That is dangerous. Let me give you a simple example. A person dies with a will that says everything goes to the children. That person also has a life insurance policy naming a sibling as beneficiary and a house jointly owned with the spouse. What happens? The life insurance goes to the sibling because the beneficiary form controls. The house goes to the surviving spouse because the title controls. The will controls only the remaining probate assets. That may be a bank account without a beneficiary. It may be personal property. It may be an account in the individual name, but it is not the life insurance and not the jointly titled house. This is not a matter of fairness. It is mechanics. And in estate planning, mechanics beat intention. That is why people get hurt. They believe the legal system will interpret the loving intent behind their documents. It usually does not. It follows the path the asset was placed on while the person was alive. Now, let us define the will more clearly. A will is a revocable legal document. Revocable means you can change it while you are alive and competent, you can update it, you can replace it, you can revoke it. But while you are alive, a will generally has no legal effect over your assets. It does not move money, it does not control your bank account, it does not manage your investments. It does not help if you become incapacitated. It waits. A will becomes operative at death. At death, it is submitted to the probate court and the court process begins. That is why a will does not avoid probate. Many people think that because they have a will, their family avoids court. That is backwards. The will is often the document that begins the probate process. It operates inside the court system. That is its role. A will can do several important things. It can name an executor. The executor is the person responsible for administering the estate. This person gathers probate assets, works with the court, pays final bills and taxes, and distributes what remains according to the will. The executor is the administrator of the probate estate. A will can also name guardians for minor children. This is one of its most important functions if you have minor children. The will is where you make your wishes known about who should raise them if both parents are gone. The court still has authority, but the will carries great weight. Without a will, that decision may be left much more open to the court process. A will can also direct probate assets if you own an asset in your individual name with no beneficiary, no survivorship, and no trust ownership. The will can direct where it goes. But a will cannot do certain things. It cannot override beneficiary designations. It cannot override survivorship ownership. It cannot avoid probate. It does not reduce estate taxes by itself. It does not provide creditor protection by itself. It does not manage your assets during incapacity. It does not control assets outside the probate bucket. These limitations matter because people often buy a will and believe they bought a complete estate plan. Sometimes they did. In a simple estate, a will, updated beneficiary forms, durable power of attorney, healthcare documents, and proper titling may be enough. But if the person thinks the will controls everything, they may be exposed. That brings us to trusts. A trust is not merely a document. A trust is a legal relationship. A grantor transfers property to a trustee to manage for the benefit of beneficiaries. This creates a separation between legal ownership and beneficial ownership. The trustee has legal control and management responsibility. The beneficiaries receive the benefit according to the rules of the trust. That separation is the reason trusts exist. A trust lets you decide not only who receives assets, but also how, when, and under what conditions those assets are managed or distributed. That is why trusts are so useful in situations involving minor children, financially irresponsible heirs, blended families, privacy concerns, incapacity planning, multiple state properties, or a desire to avoid probate. A trust can create continuity, and continuity is one of the most underestimated parts of planning. Death is not the only risk. Incapacity can be just as difficult. A person can have a stroke, dementia, an accident, a long-term illness, or a sudden medical crisis. They may still be alive but unable to manage assets. If there is no effective structure in place, the family may have to go to court to get authority that can take time. It can require medical documentation, it can require hearings, accounts may be frozen, bills may pile up. The family may know what needs to be done but lack the legal power to do it. This is the painful limbo that many families experience. A will cannot help. A will activates at death if you are alive, but incapacitated, the will is silent. This is why a revocable living trust can be powerful. If assets are properly titled in the trust and you become incapacitated, the successor trustee can step into the role and manage those trust assets according to the trust terms. The person is not asking the bank for permission in the same way an agent under a power of attorney might. The trustee is stepping into an existing legal role inside an existing structure that can reduce friction at a terrible time. And reducing friction is one of the main purposes of good estate planning. The goal is not only to distribute money, the goal is to make one of life's hardest moments easier for the people you love. A revocable living trust is created during your lifetime. While you are alive and competent, you can usually serve as your own trustee. You keep control. You manage the assets. You can amend the trust. You can revoke it. You can buy and sell property. For most daily purposes, nothing feels different. But the structure is ready. If you become incapacitated, a successor trustee can act. When you die, the trust assets can be administered privately and outside probate. If the trust was properly funded, that last phrase is critical. If the trust was properly funded, a trust that is not funded does not avoid probate for assets that remain outside it. This is one of the biggest mistakes in trust planning. People sign a beautiful trust document. It has the right names, it has the right distribution rules, it has the right successor trustee. They put it in a binder and feel protected. But the bank accounts are still in their individual name. The brokerage account is still in their individual name. The house was never retitled. The beneficiary designations were never coordinated. Then they die, and the assets still go through probate because the trust did not own them or receive them. A trust is not magic paper, it is a structure. The structure only works when the assets are placed into it or directed to it properly. Funding can matter more than drafting. That is the uncomfortable truth. Creating the trust is step one. Retitling assets, updating designations where appropriate, and coordinating the asset structure is step two. Without step two, the plan may fail. This is why estate planning is not just document signing, it is implementation. A good plan must match the actual asset map. Now let us compare a revocable living trust with a will. A will equals death, probate, and public process. It activates when you die. It operates through the court once filed. It generally becomes part of the public record. It is simple, usually less expensive, and often sufficient for straightforward estates. A revocable living trust equals life, incapacity, continuity, and privacy. It can operate while you are alive. It can allow a successor trustee to step in during incapacity. It can transfer assets privately after death. It can avoid probate for assets properly placed into the trust. It can create distribution rules that continue over time, but it costs more, requires more administration, and must be funded and maintained. Neither document is morally superior. The question is what problem you are trying to solve. If your estate is simple, your assets already pass by beneficiary designations, your state's probate process is not burdensome, your family is straightforward, and you have solid incapacity documents, a will may be enough. If you own real estate in multiple states, have a blended family, want privacy, want to avoid probate, care deeply about incapacity continuity, have minor or financially vulnerable beneficiaries, or want more control over distributions, a revocable living trust may solve real problems. The best structure is not the one someone online says everyone needs. The best structure is the one that fits your assets, your family, your state law, your goals, and your risks. That is how I think about it. Now, we need to talk about a very important misconception. Revocable trusts do not usually reduce estate taxes. This surprises people because they hear the word trust and think tax shelter. But control and taxation are connected. If you create a revocable living trust and keep control over the assets, the IRS generally treats those assets as still yours. They are still included in your estate. The trust may improve administration, privacy, and continuity, but it does not make your estate smaller for estate tax purposes. It also does not usually protect assets from your creditors while you are alive. Why? Because you kept control. If you can revoke the trust and take the assets back, then from a creditor and tax perspective, those assets are still effectively available to you. That is the trade-off. You keep control. You do not get major asset protection or estate tax reduction. An irrevocable trust is different. In an irrevocable trust, you usually give up control in meaningful ways. Because you give up control, the trust may be able to serve advanced goals such as estate tax reduction, creditor protection, Medicaid planning, long-term care planning, business succession, or wealth transfer strategies. But there is always a trade-off. You cannot keep full control and also pretend the assets are no longer yours for protection or tax purposes. This is one of the central principles in estate planning. Control and protection move in opposite directions. The more control you keep, the less protection you usually get. The more protection you seek, the more control you may have to give up. That is why you must understand what type of trust you have. When someone says, "I have a trust," that is not enough information. Is it revocable or irrevocable? Is it funded? What assets are inside it? Who is trustee? Who are the beneficiaries? What happens during incapacity? What happens after death? Does it avoid probate? Does it protect assets? Does it reduce taxes? Does it handle minor children? Does it coordinate with beneficiary designations? The word trust alone does not answer those questions. A revocable living trust and an irrevocable Medicaid asset protection. Trust are very different tools. A testamentary trust created inside a will is different again. A special needs trust is different. A charitable trust is different. An asset protection trust is different. The tool must match the job. Now let us talk about testamentary trusts. A testamentary trust is created inside a will and comes into existence after death. It does not exist during your lifetime because it is born from the will. It does not avoid probate. The will still must be submitted to the court, and the trust is created through that process. So why use it? Control after death? A testamentary trust can be useful if you have minor children or beneficiaries who should not receive money outright. For example, the will can say that assets should be held for a child used for health, education, maintenance, and support, and then distributed later at certain ages. That can be very useful, but it is not a probate avoidance tool. It is a post-death control tool. Again, the distinction matters. If your goal is to avoid probate, a testamentary trust is not the answer. If your goal is to control distributions after death through a structure created in the will, it may be useful. Every document has a job. You must know the job. Now let us talk more deeply about incapacity. Incapacity planning usually has several possible tools. One route is a court-appointed guardian or conservator. This happens when the family must ask a court to appoint someone to manage personal, medical, or financial affairs. It can be slow, public, expensive, and stressful. Another route is a durable financial power of attorney. This allows an agent to act on your behalf for financial matters if you are incapacitated or sometimes immediately, depending on how it is drafted. Every adult should consider having one. It is a vital document, but powers of attorney can sometimes be questioned or rejected by financial institutions. A bank may say the document is too old. A brokerage firm may demand its own form. An employee may be uncertain. The agent may have to prove authority account by account that can create delays. A third route is a successor trustee under a revocable living trust. If the trust owns the asset, the successor trustee steps into the trustee role and manages the trust property according to the trust terms. That can be smoother because the trust structure already exists. A complete incapacity plan often uses both. A revocable trust for trust-owned assets, a durable financial power of attorney for assets outside the trust, a healthcare power of attorney for medical decisions. a living will or advance directive for end of life wishes. These documents coordinate. The trust does not replace every other document. A power of attorney does not replace every trust function. Healthcare documents do not handle bank accounts. Each tool has a job. If one is missing, the family may face friction. If several are missing, the family may end up in court. The goal is not to create documents for decoration. The goal is to allow the right people to act at the right time with the least unnecessary resistance. This is the practical heart of estate planning. It is less about death than people think. It is about continuity when control must change. Now let us talk about probate. Probate is not always evil. Some states have efficient, inexpensive probate processes. Some estates are simple, some families have no conflict. In those cases, probate may not be a serious problem. That is why not everyone needs a trust. But in other situations, probate can be slow, expensive, public, and burdensome. If there are assets in multiple states, there may be probate in more than one state. That is called ancillary probate. If there is real estate in 2 or 3 states, the family may deal with court procedures in multiple jurisdictions. A revocable trust can help avoid that. If the properties are properly titled in the trust, that can simplify administration. This is why people with out-of-state real estate often consider trusts. Again, the asset map drives the answer. If all your assets pass by beneficiary designation and you own no standalone real estate, there may be very little probate exposure. If you own multiple properties in your individual name, probate exposure may be significant. The question is not, do I need a trust? The better question is, what would go through probate if I died today? That question forces clarity. Now, privacy probate is a court process. Court records are often public. That means a will, inventory, heirs, disputes, values, and distribution terms may become visible, depending on the jurisdiction. Some families do not care. Others care deeply. Privacy can matter if the family has wealth, conflict, business interests, public exposure, vulnerable beneficiaries, or simply a desire not to have personal affairs placed in public court records. Trust administration is generally private. That does not mean secret from all legal obligations, taxes, beneficiaries, or courts if there is a dispute. But it is not automatically filed in the probate court in the same way for some families. Privacy alone justifies a trust for others. It is not important. Again, priorities matter. Now, let us talk about blended families. Blended families create estate planning risk because the legal default may not match emotional promises. A person may want to provide for a surviving spouse while also preserving assets for children from a prior marriage. If assets are left outright to the surviving spouse, the spouse may later leave everything to their own children or new spouse, intentionally or unintentionally cutting out the first person's children. A trust can create a structure. It can provide income or support for the surviving spouse while preserving principal for children later. It can define rights, responsibilities, and timing. It can reduce ambiguity. A will can also include certain provisions, including testamentary trusts, but probate and administration may still be involved. The right solution depends on the family, assets, and goals. The point is that blended families should not rely on vague promises. Good people can still create bad outcomes when structures are unclear. Now, minor children. If minor children inherit directly, they cannot simply manage money outright. A court may need to appoint someone to manage the assets. Funds may be released at an age that may be too young for responsibility. A testamentary trust or revocable living trust can create rules for how money is used and when it is distributed. For example, assets can be used for health, education, maintenance, and support, then distributed in stages. Maybe some at 25, some at 30, some at 35. Or maybe the trustee keeps discretion longer. The right design depends on the family. But guardianship is still in the will. A trust can manage assets. A will names the guardian. Families with minor children often need both. That is why the question is not always will versus trust. It may be will plus trust plus powers of attorney plus healthcare directives. Estate planning is a system, not one document. Now let us talk about beneficiary designations again, because this is where many plans fail. Retirement accounts and life insurance can be large assets. If the beneficiary forms are old, the wrong person may receive the asset. An ex-spouse may still be named. A sibling may be named from decades ago. A parent may be named who is already dead. A minor child may be named directly, creating court complications. The estate may be named, forcing probate and tax issues. A trust may be named without understanding tax consequences. You must review beneficiaries regularly. Life events should trigger review: marriage, divorce, birth of a child, death of a beneficiary, estrangement, new estate plan, new trust, move to another state, major asset change. A will update is not enough if beneficiary forms remain outdated. The beneficiary form is a contract. The contract wins. This is why estate planning is maintenance, not a one-time event. A plan created 10 years ago may no longer match life today. Now, joint ownership. Joint ownership can be useful. It can pass assets quickly, but it can also create unintended consequences. Adding a child as joint owner to a bank account may expose the account to the child's creditors, divorce lawsuits, or spending. Adding a child to a deed can create gift tax reporting issues, loss of control, capital gains problems, Medicaid issues, and family conflict. People use joint ownership as a shortcut. Shortcuts can be expensive. If the goal is convenience, a power of attorney, trust, or proper beneficiary designation may be better. If the goal is avoiding probate transfer, on death designations, payable on death accounts, or a trust may be better depending on the asset and state. Do not use joint ownership casually. It is a powerful legal structure, not just a practical convenience. Now, let us talk about the executor. Choosing an executor is important. This person must be organized, honest, capable, and willing to deal with court bills, taxes, assets, beneficiaries, and deadlines. Family position alone does not make someone the right executor. The oldest child is not automatically best. The favorite child is not automatically best. The person who avoids conflict may not be best if conflict is likely. You need competence, you need trustworthiness, you need availability, you need judgment. The same applies to a trustee and successor trustee. The trustee role may last longer and involve more discretion. A trustee may manage assets for minors, spouse, children, or other beneficiaries. The trustee must follow the trust, invest prudently, keep records, communicate, and avoid self-dealing. A bad trustee can ruin a good trust. The document matters. The person holding the role matters too. Now, let us address cost. Wills are usually less expensive. Trusts usually cost more. That matters. Not every family should buy complexity they do not need. If a person has a simple estate, modest assets, properly aligned beneficiaries, and a state where probate is easy, a will and good supporting documents may be enough. But cost should be evaluated against the problem being solved. If a trust avoids multiple probates, preserves privacy, allows smooth incapacity management, handles blended family issues, and controls distributions for minor children, the higher cost may be rational. The cheapest plan is not always the best plan. The most expensive plan is not automatically best either. The correct plan is the one that solves real problems at a reasonable cost. That is the principle. Now, let us talk about myths. The first myth is that trusts avoid taxes. Some do, many do not. Revocable living trusts generally do not reduce estate taxes because you retain control. Certain irrevocable trusts may reduce taxes because you gave up control. Always ask what type of trust and what tax result. The second myth is that having a trust avoids probate automatically. Only funded trusts avoid probate for the assets inside them or properly directed to them. An unfunded trust is paperwork. The third myth is that a will controls everything. It controls probate assets only. The fourth myth is that testamentary trusts avoid probate. They do not. They are created through probate. The fifth myth is that estate planning is only for the rich. It is not. Anyone with children, a home, bank accounts, retirement accounts, life insurance, blended family issues, incapacity concerns, or strong wishes for how assets should move needs some level of planning. The sixth myth is that signing documents means the plan is finished. It does not. Beneficiaries must be updated, trusts must be funded, titles must be reviewed, powers of attorney must be accessible. Trustees and executors must know where documents are. Plans must be updated as life changes. Estate planning is structure plus execution. Without execution, the structure may fail. Now, let us think like a systems person. Every asset needs a pathway. A retirement account pathway may be beneficiary designation. A life insurance pathway may be beneficiary designation. A house pathway may be joint title, trust ownership, transfer on death deed if state law allows, or probate through a will. A bank account pathway may be joint ownership payable on death designation, trust ownership, or probate. A business pathway may be operating agreement, buy-sell agreement, trust ownership, or probate. A brokerage account pathway may be transfer on death, trust ownership, beneficiary structure, or probate. If you do not assign the pathway, the default rules assign it for you. That is the entire estate planning problem. You either design the system or the default system acts. The default system may not be what you want. Now let us talk about business owners. Business interests require special care. An operating agreement, buy-sell agreement, shareholder agreement, partnership agreement, or trust ownership may control what happens. If the owner dies or becomes incapacitated, who can make decisions, who can sign checks, who can sell the business, who can buy out heirs, who values the business, what happens if a co-owner and the surviving spouse disagree? A will alone may not solve these issues. A trust may help, but it must coordinate with business documents. Again, structure controls. A business succession plan is not the same as a household will. If you own a business, estate planning is also continuity planning. Now let us talk about digital assets. Modern families may have cryptocurrency, online accounts, payment apps, cloud storage, creator income, digital businesses, domain names, subscriptions, and social media accounts. These may not pass cleanly without planning access, passwords, private keys, platform terms, and fiduciary authority matter. A will saying, everything goes to my children, may not help if no one can access the crypto wallet or if platform rules block access. Digital assets need a plan, secure inventory, instructions, legal authorization, custody awareness. This is part of modern estate planning, not because it is fashionable, because assets have changed. Now let us talk about incapacity in digital life. If you are incapacitated and bills are paid online, accounts are paperless, passwords are unknown, and financial institutions reject old powers of attorney, the family may be trapped. A trust and durable power of attorney can help, but practical access also matters. Someone must know where records are, which bills exist, what accounts are owned, and who to contact. Do not confuse legal authority with practical information. Your successor trustee may have authority, but if they do not know the account exists, they cannot manage it. An estate plan should include an asset inventory, not necessarily with sensitive passwords sitting in an unsafe place, but enough guidance that the right person can locate assets and obligations. Planning is communication now. Let us discuss pour over wills. If someone has a revocable living trust, they often also have a pour over will. The pour over will acts as a backup. It says that any probate assets left outside the trust at death should be poured into the trust. But this still requires probate for those assets. The pour-over will does not avoid probate for assets forgotten outside the trust. It simply directs them to the trust after probate. That is useful. But it is a safety net, not the main strategy. The main strategy is funding the trust while alive. Again, implementation matters. Now, let us talk about estate taxes for most middle-class families. Federal estate tax may not be the central issue because the federal exemption has been high in recent years. But laws can change, state estate taxes may exist, and high net worth families need planning. Revocable trusts do not usually reduce estate taxes. But advanced irrevocable trusts and wealth transfer strategies may. If estate tax is a real concern, you need specialized planning. Do not assume your revocable trust solved it. Do not assume your will solved it. Ask directly, will my estate owe federal or state estate tax? If so, what strategies reduce that risk? What control must I give up? What are the trade-offs? Good planning begins with the right questions. Now let us discuss creditor protection. A revocable living trust usually does not protect assets from your creditors because you retain control. An irrevocable trust may provide some protection depending on state law, structure, timing, and the nature of the claim, but asset protection must be done before the problem arises. Transfers made after a creditor issue appears can be challenged as fraudulent transfers. This matters for doctors, business owners, landlords, professionals, and people with liability exposure. Do not assume a trust equals creditor protection. Ask what type. Ask what claims, ask what state law, ask what timing. Precision matters. Now, let us talk about Medicaid planning because many people confuse revocable trusts and Medicaid asset protection trusts. A revocable living trust usually does not protect assets for Medicaid eligibility because you still control the assets. A Medicaid asset protection trust is typically irrevocable and designed to remove assets from countable resources after the look-back period if properly structured and funded under state rules. That is a different tool with different trade-offs. If your concern is long-term care and Medicaid estate recovery, ask specifically about Medicaid planning. Do not assume your revocable trust solves it. A revocable trust may avoid probate, it may improve incapacity management, it may preserve privacy, but Medicaid protection often requires a different structure. This distinction can save a home. Now let us think about the person who says, I do not need estate planning because my family gets along. Good family relationships help, but they do not replace legal authority. A bank will not release money because siblings get along. A court will not skip required process because everyone is nice. A retirement account will not ignore a beneficiary form because the family agrees the will says otherwise. Good relationships reduce conflict. They do not override structure. In fact, good planning helps preserve good relationships because it reduces ambiguity. Ambiguity creates arguments. Clear structure reduces them. Do not force your family to interpret your intent after you are gone. Put the structure in place while you can still speak. Now let us talk about the person who says my estate is too small. Maybe, but if you have minor children, you need guardianship planning. If you have a bank account, car, personal property, or life insurance, you still need some plan if you become incapacitated. Someone may need authority. If you have healthcare wishes, you need documents. Estate planning is not only about millions of dollars, it is about control. Who acts? When do they act? How do assets move? Those questions matter at many wealth levels. The size of the estate affects complexity, not the need for planning. Now let us talk about the person who says, everything goes to my spouse anyway. Maybe it does under title, beneficiary designations, or state law. But what happens if you and your spouse die together? What happens if your spouse becomes incapacitated? What happens in a second marriage? What happens if your spouse remarries after you die? What happens if minor children inherit? What happens if the beneficiary forms are outdated? What happens if an asset is only in your name? The simple answer may be correct in some cases, but it must be verified. Assumptions are dangerous. Now let us discuss how to review an estate plan. Start with an asset list. For each asset, write the owner, beneficiary, approximate value, and transfer method. For a retirement account, list the beneficiary. For life insurance, list the beneficiary. For bank and brokerage accounts, list whether they are individual, joint, payable on death, transfer on death, or trust. Owned for real estate. List how the deed is titled for business interests. List the operating agreement or transfer provisions for vehicles and personal property. Understand state rules. Then compare this to your will or trust. Do they match? If the will says children inherit equally but one child is named as beneficiary on a large account, is that intentional? If the trust says assets should be managed for minors but the life insurance names minors directly, is that intentional? If a house is jointly owned with rights of survivorship but the will says something else, is that intentional? If retirement accounts name an ex-spouse, is that intentional? This review can reveal problems quickly. The plan is not the document alone. The plan is the document plus asset titles plus beneficiary designations plus powers of attorney plus healthcare documents plus actual implementation. Now let us talk about updating estate planning. Should be reviewed after major life events, marriage, divorce, birth, or adoption, death, move to another state, major change in assets, sale or purchase of real estate, new business, retirement, diagnosis, incapacity of a trustee or executor, conflict in the family, tax law changes, beneficiary changes, If a plan is old, it may still be legally valid, but no longer aligned with reality. Old plans can be dangerous because they create false confidence. You think you are protected because documents exist, but the documents may no longer match your life. Now let us return to the mental model. A will equals death plus probate plus public. A revocable living trust equals life plus incapacity plus privacy. If funded, an irrevocable trust equals giving up control to pursue advanced goals such as asset protection, estate tax reduction, Medicaid planning, or wealth transfer depending on structure. Beneficiary designations transfer by contract, joint ownership transfers by title, probate assets transfer under the will through court, guardianship for minor children belongs in the will. Funding matters more than people think. Control equals taxation in many important ways, and legal structure controls assets, not personal intention. This is the framework. Now, what should a person do next? Do not rush to copy someone else's plan. Do not assume you need a trust because your neighbor has one. Do not assume a will is enough because it was cheap. Do not assume beneficiary forms are current. Do not assume jointly titled assets match your wishes. Do not assume probate is terrible in your state. Do not assume probate is easy either. Do not assume revocable trusts save taxes. Do not assume trusts protect assets unless you know what type. Instead, gather facts. List assets, review titles, review beneficiaries, review family risks. Think about incapacity. Think about privacy. Think about children. Think about second marriages. Think about property in other states. Think about business interests. Think about long-term care. Then sit down with a qualified estate planning attorney with the right questions. The quality of your questions will improve the quality of the plan. Ask what assets will pass outside the will. Ask what assets will go through probate. Ask whether a revocable living trust would solve a real problem. Ask whether the trust will be funded and how. Ask what documents are needed for incapacity. Ask whether estate taxes matter. Ask whether credit protection matters. Ask whether Medicaid planning matters. Ask how beneficiary designations should be coordinated. Ask where guardianship is named if you have minor children. Ask what happens if a beneficiary dies before you. Ask what happens if you become incapacitated. These questions force the plan to become concrete. Now, let us talk about a painful truth. Your family will deal with the plan when you are not able to explain it. That is why clarity matters. If your plan depends on your verbal explanation, it is not a plan. If your plan depends on family members doing the right thing, despite paperwork saying something else, it is fragile. If your plan depends on outdated forms being ignored, it will probably fail. If your plan depends on a bank accepting an old document without question, it may fail. If your trust exists but is not funded, it may fail. If your will names guardians but no one knows where the will is, it may create delay. A good plan must work when you are absent, incapacitated, or dead. That is the test. Estate planning is not about making you feel organized today. It is about making the system function when you cannot speak. Now, let us talk about the emotional side. People avoid estate planning because it forces them to think about death, illness, children, conflict, money control, and family disappointment. These are hard subjects, but avoiding them transfers the burden to the people you love. If you do not make decisions now, they may have to make them later in court. If you do not clarify structure now, they may fight later. If you do not fund the trust now, they may probate assets later. If you do not name guardians now, a judge may decide later. If you do not create incapacity documents now, they may petition for guardianship later. Planning is an act of care. It is not only a legal exercise, it is a way of reducing pain for people who will already be grieving. That is why it matters. Now let us close the core argument. A will is important, but it is not everything. A trust can be powerful, but only if it solves real problems and is properly funded. A revocable trust can help with probate avoidance, privacy, and incapacity continuity, but it does not generally reduce estate taxes or protect assets from creditors. Because you keep control, an irrevocable trust can sometimes provide advance protection or tax planning, but only because you give up control. Beneficiary forms and joint titles can override the will completely. Probate controls only the assets that have no other transfer mechanism. Guardianship for minor children belongs in the will. Incapacity planning requires more than a will, and the legal system will follow structure, not what your family thinks you meant. That is the lesson. So if you have only one takeaway, let it be this. Estate planning is not about having a document. It is about making sure every asset has the correct legal pathway and the correct person has authority at the correct time. If you do that, the plan can work. If you do not, even a well-written will can leave your family with probate, public records, frozen accounts, court petitions, unintended beneficiaries, and outcomes. You never wanted. The goal is not complexity. The goal is alignment. Your will, trust, titles, beneficiaries, powers of attorney, healthcare documents, and family communication should all point in the same direction. When they do, control changes smoothly. When they do not, the legal system decides through its own mechanical rules, and those rules may not care at all about what you thought your will controlled.